For subject clear suspended, 8 John V. David Quinn suspended 6/9 of 91 for failure to pay a fine.
Cheers.
National studies have shown on a Friday or Saturday night between 9 p.m. and 6 a.m., 1 person in 10 that you pass on the road is legally under the influence of alcohol. These are the people that we're trying to remove from the roadway. And they're not always the falling down drunk. That's the classic drunk person that we see on police shows, the person that can't stand it, falls and staggers and gets sick when he gets out of his car. The person we're looking for that causes an accident a lot of times will blow from a 0.08 blood alcohol content up to a 0.12.
Started out on a normal, it was a Saturday night, probably about 7 o'clock, and it was just a few of us like any other night, having a few beers at a friend's house, not too far from where I lived, and probably stayed there till about 9 or 10.
The problem is people don't understand why we're out here. A lot of times people think you're just hassling them because they had 1 or 2 drinks and you're going to arrest them for DUI. That's not the reality of the situation at all. Normally the people that we pull over and arrest for driving under the influence of alcohol, they're averaging at about a 0.16 to 0.18 blood alcohol content. So it's not this borderline, you know, where somebody would blow a 0.09 or a 0.08. And people really don't realize what it takes to get up to that level or how to drink responsibly. Most of the time we tell adults that are 21 and older that they should drink no more than 1 drink an hour. And every time I've ever been to a drinking establishment or a party, most people are drinking 3 or 4 drinks an hour for 4 or 5 hours straight. And then they're surprised when they get pulled over and arrested for driving under the influence of alcohol, and they blow on the breathalyzer and they're at a 0.16 or 0.17 or as high as a 0.20. What we look for is, everybody always thinks the most obvious is the improper lane usage, and a lot of times that's the most dangerous drunk, the person that goes from one side of the road to the other. But there are other things that we look for that are more specific. The swaying back and forth in their own lane, or if you have a 4-lane road going over the white dotted line in between the 2 lanes. They have a tendency to stop for a stop sign either way back, a car length back, or a car length into the intersection. They may come up to a red light, stop for the light, and the light will turn green and they won't go momentarily. They may not go for 30 seconds, or they may miss the whole transition on the light and wait for the next red light.
Next thing I knew, the police were there on the scene, and they gave me the sobriety test and walking the line and all the normal things they do for that.
But we start checking for whether a person's under the influence of alcohol the time that we pull in behind them to the time that we walk up and first view them. You'll look at their eyes. The eyes are usually glassy or bloodshot. From there, we'll bring them back and we'll ask them to perform several balance tests to see what their ability is to drive a motor vehicle. And even if they're under the influence of alcohol, they know that they're failing the test. They'll feel themselves start swaying. You'll demonstrate each test to them, and they know that they're not doing the test correctly. Depending on the degree of intoxication, the more intoxicated they are, they may think they're doing the test great. From there, we'll do the walk and turn test. They'll fall off the line. We'll ask them to raise their foot. We'll ask them if they can say the alphabet, and everybody will say, sure, I can say the alphabet. And they'll get through the first 5 or 6, 7 letters, then they'll start repeating it.
They had come to the conclusion that I was intoxicated, so they arrested me, and then they took me to the station, And they just basically did routine stuff, paperwork. They gave me the option for breathalyzer, which I took, and they basically just, printed me and set up my bond, and I was free to go if, if my bond would be met. Otherwise, I would $100. Otherwise, I would have spent the night there in jail. So.
After we do the balance test, we come up to the part that is usually the most difficult and usually the most dangerous for the police officer, where we have to take them into custody. We always ask for a backup if we have to place somebody into custody, and at that time we have to search the person, handcuff them, and put them in the back. This is the most likely time that they'll begin to struggle and fight with you, and now it's starting to sink in the seriousness of the offense that they committed. We're responsible for their cars after we take them into custody, so most times we will have to tow the car in. Again, this is starting to hit them that this tow isn't going to be for free, and now this is going to start costing them money. The tow bill is usually the least expensive of all the bills they're going to have to face in the next, 3 or 4 months to deal with this DUI charge. From there, we'll go into the station, begin the booking process. We issue the tickets, we have them take the breathalyzer test, or if need be, go for blood and urine test if we think drugs are involved. That'll be done at an area hospital. And again, all of these formal things that we go through step by step, we're building a DUI arrest. If a person failed one balance test, obviously we're not going to place them under arrest. But if they fail those balance tests, if they have a strong odor of alcoholic beverage on their breath, if their eyes are glassy and bloodshot, if their driving is poor, if they're confused as to where they're going, all of this is building up to the DUI arrest. Most people think the breathalyzer test is the only thing we go on, but the breathalyzer test is only part of a DUI arrest. After the citations are issued and the breathalyzer test is taken, we will go into the booking process, which will cover the fingerprinting, the photograph, and again, you'll hear them time after time. I'm not a criminal. Why do I have to have my photograph taken? Why do I have to have my fingerprints taken? Well, they are a criminal and they committed a criminal act. From there, we will go to the bonding procedure. And again, this oftentimes surprises people. Bond for DUI right now in Illinois is $3,000. And when you say that, it usually gets their attention.
Well, when the police arrived, I pretty much knew I was going to be arrested. I tried the best I could to do all the skills, and it wasn't done the way it should have been if you were, sober. I called my uncle, and then he picked me up, and that was probably about 4 in the morning after everything was done with all the paperwork and everything. After a couple days, I contacted a lawyer of mine, and my first question was, like anyone, is there maybe some way I can get out of it?
Virtually every first offender loses their license for some period of time. And I've never seen anybody who wasn't dramatically affected by that. I've had people who are traveling salesmen, I've had people who drive truck, drive cab, and every one of them is facing the loss of, if they took and failed the breathalyzer, 90 days of losing their driver's license on a first offense. The first 30 of which there's no relief. They really do lose their license. One of the things that I've noticed in the years I've been doing this is nobody anticipated being in court for driving under the influence of alcohol. First offenders, second offenders, they never thought that it would be them.
We went to court about a month later, and it was basically very simple. The judge had given me a year's supervision, and I had to go for my evaluations for my alcohol classes.
When you walk into my courtroom, or any judge who has a DUI call or a traffic call including DUIs, you can expect to see a room with anywhere from 50 to 150 people in it who are charged with DUI or have been sentenced to DUI and are back in court reporting on their sentence or reporting if they've paid their fine, showing me their alcohol evaluation. The first time you step up, you can expect me to advise you of your rights to plead not guilty, your right to an attorney, your right to have a jury and be proven guilty beyond a reasonable doubt. You can expect me to ask you, do you wish to have a trial or are you pleading guilty? And 90% of the people in Lake County and across Illinois plead guilty to DUI. They do not contest the charge. At that point, you can expect me to tell you to go out and get an alcohol evaluation so that I can determine whether or not you have an alcohol problem or not.
I look at their alcohol evaluation to see how a professional evaluator has taken a look at this person. There are 3 classifications that are used by the Department of Alcohol and Substance Abuse. Level 1 is a non-problematic drinker. Level 2 is somebody who has a problem, and those are divided into moderate risk and significant risk. Under DASA regulations, the Department of Alcohol and Substance Abuse, 0.20 or more puts you automatically in a Level 2 classification. Level 3 are people who are deemed in need of inpatient or outpatient treatment and are normally considered alcoholics.
You can expect me to set a date for you and your attorney to come back in about a month with your alcohol evaluation and for sentencing. At that sentencing hearing, you will come before me. There will be other people in the courtroom there also that are charged with DUI or being sentenced for DUI. You and your lawyer will step up. I'll ask you if you have any testimony you'd like to give, why I should give you a lower sentence or what sentence I should give you. I'll ask the state if they have any information they want to impart on me, why I should give you a stiffer sentence. And of course that information would include prior arrests, how drunk you were that night, if there was an accident, things like that. You can then expect me to listen very carefully to all the evidence that's presented. You can expect me at that point to allow your lawyer to have a time to argue as to what sentence would be appropriate and the state's attorney to argue as to what sentence would be appropriate. You can then expect me to take into consideration all the statutory factors in aggravation and mitigation, what the legislature has set forth in the laws as to what kind of sentences are possibilities. I will consider those things. I will consider your particular case, and then I will pronounce a sentence.
What they're likely to be looking at is a period of some sort of court's monitoring of their conduct, a substantial fine of $650 on up to $1,000 for a first offender. They're looking at alcohol education and in many cases public service hours or victim impact panels. The economic effect on a family that has somebody arrested for driving under the influence of alcohol is substantial. They will be paying substantial attorney's fees, they'll be paying substantial fees for alcohol assessments, for alcohol education, and how much that is going to run depends on whether they're fit in which one of the 3 classifications. They're going to be paying fines, they're going to be doing without a driver's license for a minimum period of 30 days where they have no license whatsoever. Most families, that's a significant financial impact, that somebody else has to drive the defendant for to and from work or to and from classes for some period of time. Those factors, if they don't make an impact on the defendant, then the best thing I can do is try and permanently take away their license because they're not going to be impacted by anything else.
And it cost me $1,000 for the lawyer, and it cost me $600 for my alcohol classes, and it cost me, I had to break my lease out of my apartment because I didn't have a license to get to work, so I moved in with my uncle, and that cost me $700. And time lost off work, I'm roughly saying about $3,500 is what it cost me, and lost my license for 3 months. I had it up for a work release only for 2 months at a time. 1 month was no license at all, and the other 2 months were for working back.
I don't think people really understand these collateral type consequences to the crime until they actually experience themselves or they have a close friend that experiences it, and then they can relate to it. Otherwise, I think people can understand that if they're arrested and convicted of DUI, they may lose their license, they may go to jail, they may pay a fine, but these other type of collateral type consequences of the embarrassment when you walk into work the next day, or when you go to the family's Christmas party at Christmas time, or explaining to your son and daughter when they go to school the next day and some child there has heard that their father has been arrested, and maybe they don't even know because their father didn't tell them.
And it's something that is not taken lightly at all. If you're guilty, you're guilty. You're not going to get around much. You don't go to court and get a little slap on the hand. You could go to jail.
It is a very serious problem, and as a result, there are very serious consequences. And we're trying to make sure that the defendant, when he comes to court, understands just how serious a problem this is, and that it's not something that money will correct the problem and they don't have to worry about.
But there are other newer penalties that have been imposed by the legislature that a judge has to choose from if a judge wishes to use those new penalties as far as a drunk driver goes. Some of those newer penalties are, number one, if the person is 21 years of age or younger, I can order that person to observe an autopsy or go through a facility that rehabilitates alcoholics or rehabilitates people injured in automobile crashes. I can order a person to counseling, and every person that's convicted of DUI in Lake County and in the state is ordered to do a certain amount of counseling about alcohol use and abuse. Every single person, whether they have an alcohol problem or not, has to have education as part of their DUI experience in court.
More and more, I see the attitude of the jurors. They do not identify with the drunk driver anymore. They view the drunk driver as the man who killed Candy Leitner's daughter and started Mothers Against Drunk Driver. The public awareness of the significant problem caused by drunk drivers has really been heightened through the media in the last 10 years or shorter. And people are not as tolerant as they used to be. They, in fact, are very much less tolerant of people driving under the influence of alcohol. They do not identify with the defendant. They, in fact, identify with people who have been injured by intoxicated motorists.
To take Lake County for an example, even though fatalities in automobile accidents are down, there's still about 60 a year in Lake County fatalities. That's about 5 a month, which is a little better than 1 a week.
My primary goal as a prosecutor is to protect the public. I'm the people's representative in the courtroom. So my first goal, my first consideration is how can I best protect the public from being injured by this person.
If 5 people in Lake County won the $1 million lottery every month, people would say, boy, those are great odds. I'm going to buy even more tickets. Unfortunately, those are about the odds. But we're not talking about winning $1 million. We're talking about dying.
My job is to make sure that that person is not out there endangering other motorists when they're driving. If I don't think that that driver has learned something very significant out of their arrest, then I'm going to be opposed to seeing them back out there. I'm going to make sure that they have to go through a very stringent procedure with the Secretary of State in order to get their driving privileges back.
You know, I'm young. I should be out there doing fun things, and you know, you can't go out and do things if you don't have any money, and it certainly takes a big chunk out of your wallet.
So by the time you get done with all the costs for a DUI arrest, you're talking maybe $2,000 or $3,000 when they could have taken a cab home for let's say $60 or $70, or if they wanted to get a limo for $150. What is that as compared to $2,000 or $3,000? This is the lesson we're trying to get home to people. Get the designated driver, call a cab, have somebody come and pick you up. But they don't seem to ever want to listen to the lesson. They'd rather take a chance and see if they can get home, maybe kill themselves or kill somebody else.
10-4, 623, 1111.
623 negative, go ahead.
10-4, subject clears suspended 8 John D. David Quinn, suspended 6-9 of 91 for failure to pay a fine.
All right, 10-4, I'm going to be 1101. That's the 1055 I pulled over earlier. I'll be 1101 with 1, and I will need assistance on the booking.
10-4, 661, standing by in the station.
10-4.
Six 46, 10-8.
10-4, 646.